I am your best friend. I am your only friend. I am your best friend. It's D. Scott Crook. Welcome to HR's Best Friend, our new podcast for HR professionals and business leaders who want to make sure they stay compliant and don't get in trouble and keep their employees happy. D. Scott Crook is the Utah employment lawyer. He's consistently listed in Rocky Mountain Super Lawyers and Best Lawyers in America. He's the managing partner of Crook Legal Group. Scott is only licensed to practice law in Utah and Idaho. He is not giving specific legal advice. This shouldn't be construed as legal advice for your problem. If you need specific legal advice, please go to an attorney. Scott is an attorney. We'll leave it at that. Dad, did you like the new intro?
Oh, I loved it. Yes.
Good. I felt like we needed more music as part of this experience. And just so everybody knows, that wasn't just my idea. Scott was the one who started singing it before we started recording, and then I improved it because I have a deeper voice.
Yeah.
So, for today's episode, I'm excited about this. So, I've got a current event for us to go over. I've got a Reddit question. I've got an office episode for us to dissect. And with the current event and with the office episode, what we're going to do is we're going to play a game I just invented. It's called Illegal, Actionable, Immoral, or Normal.
Yeah.
And
Okay.
you will tell us in Utah/Idaho if this thing that I have just described is illegal, actionable, immoral, or normal. Okay?
Okay.
So the current event that we're going over, so this was on USA Today a while ago. Have you ever heard of Lizzo, Dad?
I think so.
Yeah, I'm not super familiar with her, but she is a singer. She's a famous singer. So there was a lawsuit filed. So in the suit filed in Los Angeles Superior Court on Tuesday, plaintiffs Crystal Williams, Ariana Davis, and Noel Rodriguez claim they were victims of sexual, racial, and religious harassment, assault, false imprisonment, and disability discrimination, in addition to other allegations. Lizzo, born Melissa Vivian Jefferson, Big Girl, Big Touring Inc. It's spelled GRRL, along with Shirlene Quigley, who is Lizzo's dance team captain and judge on her Amazon series Lizzo's Watch Out for the Big Girls, are named as defendants, though not all the allegations pertain to each of them. She denies them all, but we're just going to assume for this that they're true.
Okay.
So, this first one, is this illegal, actionable, immoral, or normal? And I assume that if something is illegal, it's also actionable.
I was going to say that some of these that isn't necessarily mutually exclusive. So
Right. So, and or normal. How about that?
Okay.
The lawsuit details a night out in Amsterdam in February, during which the dancers and Lizzo visited a club in the red light district called I can't even pronounce that. It was a bar in the red light district of Amsterdam, so you can use your own creativity. A location at which patrons are allowed to interact with nude performers. So it's probably not a good employee trip.
No.
The suit alleges one of the plaintiffs was pressured into interacting with a performer after repeatedly insinuating she didn't want to. Lizzo also coerced a security guard to take off his pants on stage, the suit alleges. So, illegal, actionable, immoral, or normal?
I would say that it's
assuming this was a
illegal,
Utah-based. So,
and
assuming
immoral.
this was a Utah-based company taking a trip to Amsterdam.
Yeah, so it's interesting because it can be, it's both, well, it's probably all illegal, actionable, and immoral.
Right.
Um, but to the extent that we're talking about, if this, the first question is, was this required? Okay, so if it was required, it clearly um, would be a questionable thing to do. Uh, Particularly when people would have some, there could be all kinds of objections to this. This could be religious discrimination. This could be sexual discrimination. Clearly, sexual harassment. It could also, there could be all kinds of potential claims there if a person is forced to go to a. Did you say it was a strip club?
It's worse than that. It's a
Okay.
strip club where apparently you're allowed to interact with the
Yeah.
performers.
Anything like that that would make a reasonable person uncomfortable. And if it was a supervisor or a supervisor knew about it, then you're going to have potential claims. There's,
Right.
I
So
mean, and the only thing that would save that is if it were welcome, you know, and the fact that somebody objects, well, that suggests it's not welcome.
right. Okay. Okay. Now here's the next part of this lawsuit. Lizzo is also accused of questioning Davis's, one of the plaintiffs, commitment to the tour, which she believed was thinly veiled concerns about her weight gain, which Lizzo had previously called attention to after noticing it at the South by Southwest Music Festival. Illegal, actionable, immoral, or normal?
So weight, commenting on somebody's weight is not illegal. I don't know if it's normal. Um, it can be, however, it can potentially be a, you could potentially have some kind of claim if it was related, for instance, to a disability. If the weight gain was because of some, side effect of a drug or because of the disability a person had, and it was preventing them from doing particular things. And so, or if you treated somebody as disabled because you thought they had gained weight. But ordinarily, if it's just a weight issue, that is in Utah at least not protected. Um, so you can be mean to people who are too big.
So immoral?
Yeah, it's probably not nice. So I would say immoral. Yeah.
Okay. Okay, Quigley. So this was like one of the managers. Quigley is accused in the lawsuit of simultaneously berating the dancers who engaged in premarital sex based on her religious views and also acting out sex acts and making sexually explicit comments. So she's both telling people not to have premarital sex, but she's also doing those other things at the same time. In the suit, hold on, I'm not finished.
Oh, okay.
In the suit, Davis said Quigley kept tabs on her virginity, and Rodriguez claimed she was singled out by the team captain for being a non-believer. So there's lots of stuff going on there.
Right. So definitely in Utah, the taking action against anybody or making a hostile work environment, where a reasonable person would feel like the terms of their employment were affected, based on somebody's religion, would be illegal. The also keeping track of somebody's virginity or not, to the extent that that's related to religion, or to the extent that that's related to, sexual activity, both of those could be actionable claims. Again, it's whether a reasonable person would feel, like it affected the terms of their employment. You can't, of course, separate each particular act out one by one and say, oh, well, that's not bad. You kind of have to look at it in the whole circumstance, obviously.
Okay, so
seems a little odd that they would be taking that action while at the same time forcing everybody to go to a bar in Amsterdam. But, who am I?
You're the Utah employment lawyer.
Yeah.
Okay. All right. The dancers also claimed that Lizzo strongly preferred the dance cast not take on other jobs between her tours, meaning plaintiffs would not be paid during the break, but should not be taking on other jobs either. Due to the company's soft prohibition on plaintiffs and their team members taking on other jobs, they became wholly financial dependent on the income they received for their performances on the special tour the lawsuit alleges. Illegal, actionable, immoral, or normal?
That's not illegal. It's definitely not actionable. There's too much missing from the context of that to really to delve into it. But the fact is that employers can have preferences that you not work for somebody else, and that's not something that's normal, actually. And whether somebody becomes dependent on somebody for work, that's not really an actionable claim.
Okay.
And it's kind of normal, actually.
Okay. All right. We got our first normal.
Yeah.
All right. That wraps up that current event. Good job. You did well.
I hope so.
So, next, we have our Reddit question. So I'll read this for you.
Okay.
And actually, I can present. So our video audience can read this at the same time. Here we go. So, good afternoon, my fellow HR professionals. Over the last 12 months, our organization has seen an uptick in accommodation requests for unscheduled absences. These requests are coming from employees who don't meet the minimum criteria to qualify for FMLA. For example, we've had 2 per diem employees from different departments, entities who were consistently calling out sick or just going to come in. They have been issued progressive discipline for absenteeism. As a result, they put in an accommodation request as a result of their medical conditions for unscheduled absences, so they would not be subject to discipline. These 2 employees are a bit baffling to me because they are per diem and work full-time elsewhere. Not sure why they are clinging on their per diem positions. Now I'm dealing with a request from a full-time employee who is just hired but is consistently calling out. My colleagues are getting similar requests. Our stance as an organization is that predictable attendance is an essential function of your job, and thus we have denied these requests. We go through a thorough interactive process with the employee before coming to this conclusion. We outline the specific impact their absences have on their departments. So, as an employment lawyer in Utah or Idaho, how would you counsel this HR professional?
Well, that is interesting. I mean, it sounds like they're being careful about what they're doing, but this raises actually 2 interrelated issues, and it's one that comes up frequently. It doesn't always have to do with like a unexcused absence, for instance. It can be other types of things, but it can be like taking extra breaks and that sort of thing. But FMLA, of course, only applies to certain employees who qualify. They have to have worked 1,250 hours for the previous year before they qualify as an employee that is entitled to FMLA. And then they're entitled to 12 weeks of unpaid leave under the FMLA leave statute. There's no difference in Utah. That there's not an additional leave entitlement. And so the question often comes up is if somebody, for instance, has a condition, let's say they get in an accident or something, and so they've had to leave work. Maybe they injured their back. They're supposed to be out for 12 weeks. They get a return to work at the end of the 12 weeks that says, the employee can return to work, but will need an accommodation, for instance, having to rest more frequently, take breaks more frequently. And so that often comes up. Other times people may have, for instance, like somebody might have a cancer diagnosis, and sometimes they've got to take more leave than 12 weeks that are allowed. But just because FMLA runs out doesn't mean that at that point the employer can just terminate the employee. You still have the ADA. If the ADA applies, and most of the time it will in an FMLA situation, because the definition of disability is really broad. It was redefined to include almost everything now. So even things that people wouldn't view as disabilities traditionally. But anyway, this is something that happens all the time. And the answer is anytime anyone asks for an accommodation like that, you have to go into an analysis. You have to look at what the essential functions of the job are, which means you need to know what they are, and they should be in the job description. You should talk to the employee about what that accommodation means. And a lot of times predictable employment or being on site is an essential function of the job. And if you do find that, and then an employee still insists that they take unexcused absences, if they can't perform the essential function of the job without an accommodation, then they're not qualified, and the ADA does not protect them.
Okay. Well, thank you. All right. So now we've been through our Reddit question, tackled our current event. So now we're going to talk about Diversity Day from The Office. And we're going to play illegal, actionable, immoral, or normal with this episode.
We can just say, yes, they're all not normal. We don't even have to. Oh. You don't even have to keep going. Yeah.
So Diversity Day, that's the episode where, so Michael, the episode opens with Michael explaining that it's Diversity Day, and there's a guest speaker coming to Dunder Mifflin to talk about diversity in the workplace. Michael claims that he's wanted this for a while. Corporate mandated it without Michael having to talk to them about it, though. But Michael still believes it's very important. In the episode, it's revealed that the diversity trainer is there because of the Chris Rock routine that Michael subjected everyone to, that he acted out. So, I mean, but anyway, I'm going to take the plot points from this episode.
Okay.
And you're going to tell me if it's illegal, actionable, immoral, or normal. When the meeting begins, Michael tries to take over by talking about how he doesn't even see Stanley as a black man. The representative explains that's not the point here. No one is expected to be colorblind. That's just fighting ignorance with more ignorance. Is Michael saying he doesn't see Stanley, who's black, as a black man, illegal, actionable, immoral, or normal?
That's a good question, because it's hard to know. I mean, the problem is you're ripping it out of the context of everything. If someone just said, right, I don't see him as a black man, of course that's not illegal, and it's not actionable. However, if in the context of other things, like other behavior, that might be considered, something that would be.
So if there was a pattern of things like that?
Well, no, not of that particular statement, but if it was in context with other things, that may make that appear to be racist. Because saying that you don't see somebody as black is necessarily racist. But if it's in the context of other statements or other conduct, it could be construed somehow as racist. Or,
Okay.
and if it is, then that creates the next level of question, which is, if it's racist, is it something that is actionable or illegal?
Okay.
The fact is that
basically,
it may or may not be.
to know if it's illegal or actionable, you would have to have more context.
Yes.
But to know if it's immoral or normal, we would have to know Michael's heart. Okay.
I suppose.
Okay.
Yeah.
All right, here's the next one. Illegal, actionable, immoral, or normal. Then Michael decides everyone should go around the room and name an ethnicity that he or she finds attractive. Dwight claims he's attracted to, quote, whites and Indians. The representative does not think this is a good idea. He asks for Michael's permission to run the session himself, and it would be easier if Michael sits down. He explains that he asked each of them to write down an incident that offended them. He would like volunteers to assist him. Dwight asks that they don't do anything involving gays. So is there anything in there it's not normal? So is there anything in there that's illegal, actionable, or immoral?
It's again, it's contextual. All of it's bad. Could it be illegal? Yes. At the time, interestingly, at the time that Office episode was aired, the fact that Dwight said he didn't want to have anything to do. I mean, he didn't want to talk about gays. That arguably would have been not illegal, because at the time, I think I don't know what year it was, but under Title VII,
it was like 2005 or 2006.
Yeah, at the time, there was no protection in Title VII, which is the federal statute, or in Utah, that would have protected against discrimination on the basis of sexual orientation. Now, if there had, so his statement about people being gay would not have created an issue. It would now. But even back then, if he treated people stereotypically based on what he thought how they should act as a man or a woman, that could have been considered sex discrimination. So all of it is everything Michael did and Dwight said in that, if you've seen the episode, in the context, would not be good. And whether it's actionable or not is another question. But that's the problem with doing harassment training anyway. You're making people uncomfortable and you're bringing up things you have to talk about. So anyway.
Okay, so question. So if something is actionable, is it like the company who gets in trouble? Is it the individual who does the thing? Like, how does that work?
In Utah, there is no individual, and under the federal statute, there is no individual liability.
Okay.
For discrimination, which means the company only has potential liability, and that depends on a few things as well.
Okay.
That does not mean, though, that an individual can't be sued individually if the behavior is so bad. You don't have a discrimination claim against them, but you could have, for instance, an assault claim or a battery claim or something, depending on the.
Okay. Here's our next illegal, actionable, immoral, or normal. So then the diversity trainer passes out forms and asks everyone to sign it, saying that they've seen it. Michael refuses because he didn't learn anything. Privately, the instructor explains that they both know he is here because of Michael's behavior. Michael argues that this office is racially advanced enough that it really doesn't need a diversity lecture. Brown tells him, the instructor tells him it does because it's Michael that caused the need for it. He only needs Michael's signature. But he had the whole office go through the seminar because he didn't want to make Michael feel singled out. Michael is offended that this really wasn't about diversity then. And Michael signs the form and then jokes after the fact that he signed it Daffy Duck. So my question is, Michael doing that, does that create liability for the company? Basically,
No.
like, okay.
No. And in fact, a lot of times when you ask for people to do signatures on forms, the reason you're doing it is just so that you can have evidence that they actually attended, right? It's not generally that the reason why people do that is you can say, okay, they participated in everything. Now, the fact that he signed it as Donald Duck or Daffy Duck, I can't remember which one. But the fact that he signed it that way, you're hoping the diversity trainer noticed. And if he did, he probably just wrote at the bottom, signed in my presence by Michael Scott as whatever. And as long as there's a note there, you're fine. So it doesn't do anything.
Yeah. Okay. So now the episode ramps up a notch. Okay. Because Michael decides that he's going to take the diversity training into his own hands. So he orders everyone into the conference room. So Michael introduces himself and describes his ethnic breakdown. So here's the real thing. So Michael hands out cards with different ethnicities on them. The employees are supposed to take the card and then try to guess their pretend ethnicity by how their coworkers treat them. Right? So if you had a card that said white on it, people were supposed to treat you how you would as a stereotype. Right. Okay? Stanley, who is black, is inadvertently given black. Dwight is Asian, but can't guess it based upon people telling him they like people's food, or does he eat lots of rice? Michael chooses Martin Luther King for himself. And he insists Pam stir up the pot by getting extreme. Kevin is Italian and is trying to get Angela to guess that she's Jamaican by using the word mon and talking about beaches and asking her if she wants to get high. So the question is, so this seems pretty extreme. So is this event, because you've talked about context, is this event in itself illegal, actionable, immoral?
Oh, yes. There's no question. It is illegal. It is actionable. The problem is this. I mean, he's Michael is saying, well, this is diversity training or whatever, but the fact is it's not, and it's clearly, it would be offensive. I think most reasonable people would be offended by what happened. It's clearly this would just, in the context of everything, there would be, and the fact that Michael is the supervisor who is doing it, it just creates huge problems. I mean,
so if this was one of your clients and you like walked in, you would say, stop now, and pull the fire alarm.
I probably would not pull a fire alarm, but I would try and get it stopped as quickly as I could. Yes.
Okay. Well, good. Well, thank you. This was a good episode. Everyone, make sure that you subscribe and rate us. Hopefully we entertained you and you learned something. And we'll talk to you next time.
All right. Thank you.